Welcome to this lecture by pro-legal minds on warrant cases, definition, procedures, and legal framework, a significant area of criminal law addressing serious offenses punishable by life imprisonment or severe penalties. In this session, we will explore the structured trial procedures, rights of the accused, and key provisions under the law to ensure justice is served while safeguarding individual rights. Stay tuned as we navigate through this critical aspect of legal proceedings with relevant examples and case studies. A warrant case is a criminal case involving offenses punishable by death, imprisonment for life, or imprisonment exceeding 2 years. These cases involve more serious offenses, requiring warrants for the accused's appearance in court rather than mere summons. The detailed procedures in such cases ensure thorough investigation and fair trial practices, adhering to the principles of natural justice. Purpose: the categorization of cases as warrant cases ensures that severe offenses are rigorously handled. The structured procedural safeguards in warrant cases protect the rights of both the accused and the victims while maintaining justice's integrity. Key provisions and procedures for warrant cases under BNSS. 1. Initiation of a warrant case, BNSS sections 248 to 260. Explanation: warrant cases can be initiated either through a charge sheet filed by the police after an investigation or through a complaint directly made to the magistrate. Police are required to conduct thorough investigations and file a charge sheet if sufficient evidence exists. Example: an armed robbery is categorized as a warrant case because it involves severe punishment exceeding 2 years. Case law: State of Uttar Pradesh vs. Naresh, 2011, the Supreme Court held that the filing of a charge sheet is a critical stage in warrant cases, ensuring that the prosecution is based on credible evidence. 2. Stages in warrant case proceedings. A. Filing of charge BNSS sections 234 to 247. Explanation: charges are formally framed against the accused, clearly specifying the offenses. The accused has the right to challenge these charges or seek discharge if the evidence is insufficient. Example: if the accused in an assault case finds the evidence inadequate, they can file a petition for discharge based on lack of probable cause. Case law: Union of India vs. Prafulla Kumar Samal, 1979, reinforced the principle that charges should only be framed if a prima facie case is established. B. Evidence presentation and witness examination, BNSS sections 261 to 273. Explanation: the prosecution presents all evidence, including documents, physical evidence, and witness testimonies. The defense has the right to cross-examine witnesses to test their credibility and counter the prosecution's case. Example: in a murder trial, forensic evidence is presented, and witnesses are cross-examined to establish the sequence of events. Case law: State of Maharashtra vs. Sukhdev Singh, 1992, highlighted the importance of cross-examination in warrant cases to ensure a fair trial. C. Arguments and conclusion BNSS sections 274 to 282. Explanation: after evidence presentation and cross-examination, both the prosecution and defense present their arguments, summarizing the case and highlighting inconsistencies or supporting facts. Example: the defense may argue for leniency based on mitigating factors, while the prosecution emphasizes the gravity of the crime. Case law: Ranjit Singh vs. State of Punjab, 2009, emphasized the need for structured argument stages in warrant cases to protect the rights of the accused. Session: BNSS sections 248 to 260. Explanation: serious cases, such as those involving attempted murder or rape, are heard before a sessions court. The accused pleads guilty or not guilty, and the trial proceeds accordingly. Example: in a case of grievous harm, the sessions court conducts a detailed trial due to the severity of the offense. 4. Plea bargaining, BNSS sections 289 to 300. Explanation: plea bargaining allows the accused to plead guilty in exchange for a reduced sentence. However, it is generally restricted to offenses that do not involve serious societal harm. Example: An accused in a theft case may opt for plea bargaining to avoid the uncertainties of a full trial. Case law, Thippaswamy v. State of Karnataka, 1983, clarified the principles of plea bargaining, ensuring it is used judiciously. 5. Summary trials for minor warrant cases BNSS sections, 283 to 288. Explanation: for minor offences within the scope of warrant cases, magistrates may opt for a summary trial to expedite proceedings while maintaining fairness. Example: a minor fraud case may be handled through summary trial procedures to save time and resources. 6. Irregular proceedings and fair trial principle, BNSS sections, 197 to 222. Explanation: provisions ensure that trials adhere to procedural fairness. If irregularities occur, corrective measures such as retrials or exclusion of improperly admitted evidence may be ordered. Example: procedural lapses in evidence collection may lead the court to direct further investigation. Case law, Zahira Habibullah Sheikh v. State of Gujarat, 2004, addressed the importance of procedural fairness in ensuring justice. General principles and rights of the accused. Right to bail and bonds BNSS section 478 to 496. Accused individuals may apply for bail, subject to judicial discretion, based on the nature of the offense, flight risk, and potential for evidence tampering. Example: an accused in a serious fraud case may be granted bail if they show they are not a flight risk. Case law, Gudaikanti Narasivulu v. Public Prosecutor, 1978, reinforced the principle of granting bail unless there is a compelling reason to deny it. 2. Right to legal representation. The accused has the right to legal representation. If unable to afford a lawyer, the court appoints one to ensure fair trial practices. Case law, Husainara Khatun v. State of Bihar, 1979, affirmed the right to free legal aid for the indigent. 3. Right to appeal. BNSS sections, 413 to 435. Convicted individuals have the right to appeal a decision to a higher court on grounds such as factual or procedural errors during the trial. Example: an accused convicted of robbery may appeal the decision, arguing that evidence was improperly admitted. Conclusion: warrant cases represent the more serious side of criminal proceedings, requiring detailed and structured trials. The BNSS and CRPC provide robust frameworks to ensure fairness, safeguard the rights of the accused, and maintain the integrity of the justice system. Adherence to these procedures ensures that justice is delivered effectively and equitably. Thank you for watching this session by Pro Legal Minds. We hope you found the content insightful and helpful. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed. Stay empowered. See you in the next session.